Thank you very much for joining us, and welcome to this Venable webinar addressing changes to the MISO interconnection queue in 2016. My name is David DeSalle, and I will serve as the chairperson for today's discussion. I'm joined by my colleague, Mike Splete. As you would expect, the opinions expressed in this presentation are our own, do not represent the views of any particular client or of our law firm. Some housekeeping issues. As a reminder, the audio for today's event will be broadcast through your computer speakers. Be sure they are turned on and the volume is turned up. If you have any problems with the audio quality during our presentation, I just advanced the slide so you can see the number. The audio dial-in is 888-637-5631. The conference ID is 752-39261. You can also use the chat feature on the ReadyTalk interface, and a representative will assist you with your audio and technological questions. We will allow time to address your questions at the end of today's presentation, so please submit your questions using the chat feature on the ReadyTalk portal anytime during our discussion, and we will try to save time to get to them at the end of the presentation. And finally, CLE credits. You practitioners in New York and California, the webinar has been approved for 1 hour of continuing legal education credit. Listen for the code word that we will reveal later in our presentation. You will need that code word for registering your CLE credits. I believe we'll be making this presentation and recording available for viewing and listening at a later date, and your colleagues who are unable to participate today may still be able to view the webinar and apply for CLE credits in New York and California. As I mentioned, my name is David DeSalle. I'm a partner here in Venable's Energy Practice Group. I've had the privilege of helping a variety of clients since 1995 with a host of energy issues before state and federal courts, regulatory agencies, including state public service commissions, the Federal Energy Regulatory Commission, and the U.S. Department of Energy. For approximately 13 years, I've had particular experience working on issues related to the interconnection of MISO generation resources and their participation in MISO's energy and ancillary services markets. I've served as one of the leading outside attorneys involved in drafting and revising MISO's Generation Interconnection Procedures, from the initial Order 2003 compliance filing through 3 successful phases of queue reform. I would like to note that I did not provide any legal services related to the 4th phase of MISO queue reform that was filed on December 31st, 2015, and was rejected without prejudice by FERC last week. I've been involved in the negotiation of well over 100 generator interconnection agreements. I've worked on dozens of multi-party agreements involving the funding and construction of network upgrades and interconnections between and among transmission systems and distribution systems. I'd like to introduce to you my colleague and co-presenter, Mike Splete.
Hi, I'm Mike Splete. I've been working on energy issues since 2005 with a focus for much of that time on electric generator interconnection, transmission cost allocations, and electricity markets, and also NERC reliability standards. I've also had experience with cost of service rates, market rates, and oil and natural gas pipeline matters, and in representing clients before FERC and at state commissions in hearing and in settlement. And specific to interconnection, I advise clients on a number of first impression issues under Order Numbers 2003 and 2006, the Small Generator Interconnection Procedures, including the tariff revisions to expedite the MISO queue process. And prior to that, I was a law clerk at the Federal Energy Regulatory Commission, Office of Administrative Law Judges.
Okay, enough about us. It looks like 2016 is going to shape up to be one of the most eventful years in recent memory for stakeholders that are involved with the MISO generation interconnection process. If you've been following along in the past 10 days, last week the 4th major overhaul of MISO's interconnection process was acted on by the Commission. The proposal was roundly rejected by FERC without prejudice, meaning that the door has been left open for MISO to develop a new proposal and submit it at an appropriate time. But in other recent news, FERC instituted a Federal Power Act Section 206 paper proceeding in response to the September complaint from E.ON and Invenergy alleging preferential treatment of external generators. FERC will determine whether the terms and conditions governing network resource interconnection service for external generators, that's ENRIS, whether they are just, unreasonable, unduly discriminatory, or preferential. And MISO has been ordered to make a compliance filing in the near future to make clear either that the M2 milestone payment is applicable to all customers or show that it should not be required to do so. And MISO must also clarify the services that it provides and the process for receiving that service. And then thirdly, last week, the Commission announced a staff-led technical conference to be held this May 13th, 2016 at FERC. The purpose of this conference is to discuss issues related to AWEA, the American Wind Energy Association's June 2015 petition for rulemaking. AWEA had petitioned the Commission to make certain regulatory and policy changes to the interconnection procedures in order to, quote, remedy unduly discriminatory and unreasonable barriers to generator market access, end quote. In addition, in our conference, we will explore some other generator interconnection issues, including the interconnection of energy storage. Then finally, the notice indicated that the discussions at the conference that FERC staff will preside over may involve issues raised in a host of proceedings that are currently pending before the Commission. If we flip to the last two slides of the slide deck, which we'll do shortly, you'll see in the PowerPoint we have included all those proceedings in the Hot Topics Dockets to Watch slide for your convenience so that you can monitor those dockets and track these issues as the Commission addresses them. So the purpose of our discussion today is to provide a history of the MISO interconnection queue issues and an overview of the process, to address the standard of review applicable to any variations from the Order 2003 process that are proposed by MISO in the future, to review MISO's recent proposal to make comprehensive changes to the GIP through Queue Reform 4, and explore the quote-unquote guidance that FERC has offered in its order, to engage in a little prognostication regarding whether MISO will make another attempt at Queue Reform this year, and discuss some other developments that we think are likely to occur in 2016. And time permitting, we will also address some other issues of interest, perhaps the ENRIS proceeding, and again, we'll revisit some of the issues to watch for the May 13th technical conference at FERC. Plus, we would like to answer your questions at the end of our presentation. Now let's start with a short history lesson.
This is Mike again. As David mentioned, we wanted to give a very brief history of the MISO interconnection queue issues and an overview of the interconnection process for anyone on the line who isn't familiar with them. We'll keep this pretty short and cursory because probably many of you are familiar. But this process from FERC began with Order number 2003 when the Commission issued standardized large generator interconnection procedures, LGIP, or we'll also refer to GIP in the MISO case, and a standardized large generator interconnection agreement, the LGIA, and also in MISO generally referred to as a GIA. And this was intended to be adopted by transmission owners and incorporated as a pro forma agreement under their open access transmission tariff. And in doing this, the Commission had three goals. First, to minimize opportunities for undue discrimination. Secondly, to expedite the development of new generation while protecting reliability. And third, to ensure that rates are just and reasonable. And if any of you recall the pre-Order 2003 world of generator interconnection, at that time most transmission owners had their own specific interconnection agreements.
This is David again. When I was representing independent power producers in the early 2000s, interconnection was a very frustrating and inefficient process. I would have to keep copies of all the particular transmission owners' agreements on my shelf for reference, trying to identify the most favorable terms to pick and choose from for my clients. It was a process that lacked transparency and efficiency. It really lended itself to worries about undue discrimination, and there was a significant disparity in negotiating leverage between our merchant generation clients and the incumbent transmission owners to whom we were trying to interconnect. As counsel at that time to several merchant generators, the FERC reforms in Order 2003 really were a welcome relief to our clients and significantly helped to streamline the generator interconnection process.
And At that time, I was finishing up my time as a law clerk at Federal Energy Regulatory Commission, and I remember at that point some of the old hands who had been there a long time telling me that this really was a big deal, and going down to see the presentation on it, and I hadn't really realized at that point in time the practical implications, but it really was a large change for the industry. And now we wanted to take a quick look back at MISO's compliance filing for order number 2003. And your brief takeaways from this phase of MISO interconnection history are the innovations of group studies, and secondly, the ability to process interconnection requests out of queue order in certain circumstances. And in MISO's compliance filing for order number 2003 and also 2003A, MISO explained that due to the geographic expanse of the MISO footprint, it was inefficient to process interconnection requests according to the time of receipt without regard for geography and where they were located. So MISO proposed revisions to the Order 2003 pro forma LGIP in order to use a group study approach to queue processing. MISO also saw changes to the pro forma LGIP and LGIA that would permit MISO to study individual requests out of queue order based on the electrical remoteness of the generating facility or requests of the interconnection customer, subject to several conditions. These included MISO's concurrence with the request, its ability to dedicate adequate resources to perform the study, and also the interconnection customer having to accept the financial risk of restudy and reassignment of upgrades when the interconnection request became the next in queue. The Commission accepted MISO's proposal to process interconnection requests in groups and out of queue order as it was proposed, and conditioned the MISO on MISO meeting certain timing requirements in order number 2003 and 2003A. So far, so good. These are improvements to the prior process, and progress is being made. But later in the mid to late 2000s, there was a significant increase in the volume of generation seeking to interconnect to MISO and in other RTO regions. And MISO in particular fell behind its study timelines for a number of reasons. And FERC responded to these concerns that were raised by multiple stakeholders, and in 2008 held a technical conference regarding interconnection queuing practices and queue-related issues that emerged after the issuance of Order 2003. And the Commission issued an order directing the RTOs and ISOs to develop and propose their own solutions to issues related to delays and backlogs in processing queues. And this gave some room for independent entity variation because some of the issues faced by different RTOs would vary from region to region in the types of requests they would receive. And in order to remedy the clogged queue and the delay in completing interconnection studies, MISO at that point in 2008 worked with its stakeholders and created the Interconnection Process Task Force, the IPTF, to identify and correct the parts of its queue management procedures that were not functioning very well at that point. And the IPTF is still a standing committee, and it still meets to address interconnection issues at MISO. And so for anyone who's interested in those issues and isn't already a participant, that would be an excellent way to keep track of what's going on in MISO and any response to the current order. And as a result of the stakeholder process in 2008, MISO proposed, and the Commission largely accepted, revisions to Attachment X of the MISO tariff, which is the MISO GIP. And we refer to that as Q Reform 1.
This is David DeSalle again, but before we get into the details of Q Reform 1, we should briefly go over the legal standard that was established by the Commission for changes from the Order 2003 Interconnection Procedures and the Pro Forma Interconnection Agreement. The Commission applies an independent entity standard to evaluate RTOs and ISOs proposals for revisions to the procedures outlined in Order 2003. This is usually referred to in MISO parlance as the independent entity variation. Under this standard, independent entities such as RTOs and ISOs are allowed more flexibility in proposing variations than are non-independent entities. It's primarily because the RTOs and ISOs do not have affiliated generation, and thus they're less likely than non-independent entities to favor one generator over another. Under the independent entity standard, MISO has a burden of demonstrating that its proposed variations are just and reasonable, are not unduly discriminatory, and that they would accomplish the purposes of Order Number 2003. MISO was successful in meeting these three independent entity variation standards, or the standard through the three prior phases of queue reform. Last week's attempt was not successful.
Thanks, David. And a quick summary of the prior queue reforms. Queue Reform 1, your short takeaway from this phase of MISO queue reform would be, first and foremost, a change in the MISO process from a first-come, first-served approach in processing the interconnection queue to a first-ready, first-served approach. And those revisions modified the MISO GIP to limit delays caused by inactive projects in the queue. Among other things, MISO revised its procedure for processing interconnection applications from first-come, first-served to a process where that was based on the progress a generation project had made toward commercial operation, essentially first-ready, first-served approach. And this is a significant innovation and improvement on the pre-Order 2003 and early Order 2003 world. Under these procedures, an interconnection customer entered what was called the pre-queue phase, during which MISO performed a feasibility study to determine whether the transmission system could accommodate the interconnection request and whether the project could move directly to the second phase of the queue, the definitive planning phase, or the DPP, or whether it should proceed to the first phase of the queue, the system planning and analysis phase, also the SPA or SPA, for additional study. And if a project was not eligible to proceed to the DPP, the customer entered the SPA phase and underwent a system impact study. And after receiving its study results, the customer would then have to decide whether to fulfill certain requirements referred to as the M2 milestone to enter the DPP. Requirements included payment of a study deposit and certain other accomplishments that the interconnection would have to demonstrate. In the DPP phase, customer would receive a system impact study review that would give an approximation of the type and cost of upgrades that would have to be funded to facilitate its interconnection request. After receiving this information, the customer would then have to decide whether to fulfill the M3 milestone to undergo a facility study. And after completion of the facility study review, the interconnection customer would have the opportunity to negotiate an interconnection agreement, or TIA. And this is a three-party agreement among the transmission owner, MISO, and the interconnection customer. Projects that had not yet started a facility study as of the effective date of the new GIP were subject to all of the provisions of the new GIP, and projects that had started a facility study were only subject to revisions relating to suspension.
Okay. This is David DeSalle speaking again. That takes us to Queue Reform 2. Your takeaway from this phase of MISO interconnection reform is the creation of new pro forma facilities construction agreements. These were intended in part to resolve the problem that was being experienced in many parts of the MISO footprint regarding the lack of robust transmission infrastructure in areas where there were rich wind, in particular wind resources, and in part to eliminate the free rider problem that was being experienced. The changes were really designed to allow a degree of cost recovery for network upgrades that were built to accommodate a higher queued project or group of projects where the same upgrade would also benefit a lower queued project or group of projects that came in slightly later in time but in the same electrically proximate area that also benefited from the upgrade. It was sort of a balancing of the equities approach. So in 2009, MISO proposed and the Commission accepted additional revisions to its GIP that it characterized as the second phase of interconnection queue reform. MISO had explained at the time that the revisions were intended to address physical constraints and streamline the processing of interconnection requests. The physical constraints were mainly the lack of transmission infrastructure that was delaying the interconnection of new generation in many areas of the MISO footprint. Again, as I had mentioned, more specifically, regions rich with wind generation resources, remote from load, and lacking in robust transmission infrastructure. It would be cost prohibitive for a single interconnection customer to bear the burden of paying for a significant network upgrade. MISO observed this as a first mover problem, where interconnection studies showed that significant network upgrades associated with the incremental capacity of the first mover was needed to accommodate the next interconnection request, triggering the need for the upgrades, but really the upgrades were attributable to a group of interconnection requests being studied or that could be studied together. Recall, studied together under the first approach that MISO had to its innovation and study process, group studies. While later interconnection requests electrically proximate to the area would avoid bearing the cost of significant network upgrades if they did fall upon the higher queue project. So to address these concerns, MISO put in place two new pro forma agreements in the GIP, a facilities construction agreement intended to cover a single interconnection customer, and a facilities construction agreement for multiple interconnection customers, the MPFCA, that was intended to cover a group of customers contributing to a common network upgrade.
Thanks, David. This is Mike again. And finally, we had Q Reform 3 in 2012, and your takeaway from this phase of Q Reform is the ability of projects to linger indefinitely in the SPA phase so long as studies were refreshed every 18 months. The beefed up cash at risk M2 milestone payment to proceed to the DPP, and the requirement to fund a significant portion of any network upgrades or to post security to fully fund required network upgrades upon execution, or the unexecuted filing of the GIA. And in 2012, the Commission conditionally accepted, subject to further compliance, additional revisions to MISO's GIP that it characterized as the third phase of interconnection queue reform. These reforms were intended to extend the idea of the first ready, first served queuing process by removing timelines for interconnection customers in order to allow them to proceed at their own pace. So this allowed some projects that were not ready to essentially stay in the queue in sort of a suspended state, provided they had studies updated on a recurring basis. And the Commission found that MISO's proposed transition provisions were reasonable in light of the issues that MISO was experiencing in the queue at that time. Specifically, the Commission accepted MISO's proposal to eliminate the timelines for exiting the SPA phase, the system planning and analysis phase, such that the interconnection customer may remain in this phase indefinitely as long as it refreshed its study every 18 months. The Commission also accepted MISO's proposal to limit the modifications that can be made after an interconnection customer enters the DPP. And the Commission further accepted MISO's proposal to implement two new payments, subject to MISO revising the tariff to address certain issues identified by FERC. Under the revised procedures, the interconnection customer may move to the DPP at the time of its choosing by providing a study deposit, providing necessary information, and making the M2 cash at risk payment for the M2 milestone payment. As in the system planning and analysis phase, an interconnection customer was required to complete and execute an interconnection study review form. Once in the DPP, most modifications by the interconnection customer would be deemed to be material modifications, and certainly these would not be permitted. Additionally, an interconnection customer was required to make an initial payment toward its network upgrade costs within 30 days following the execution of its Generator Interconnection Agreement, or GIA, or the filing of the GIA unexecuted with the Commission. In particular, the interconnection customer is required to either pay a certain percentage of the total cost of its network upgrades or to provide security equal to 100% of the cost of network upgrades.
Which brings us to the more recent history, post-2012 through the end of last year, recent developments. So why did MISO pursue a fourth phase of queue reform at the end of 2015 if the three prior phases were successfully implemented? MISO proposed the new changes to its restudy, mostly to its restudy process, explaining that it was experiencing new issues in the years following its previous interconnection effort. Again, Q Reform 3 was the most recent one, completed in 2012. MISO explained that in a joint effort with its stakeholders, mostly through engagement with the IPTF, its stakeholder group that's dedicated to interconnection issues, but also numerous inputs from individual stakeholders, that they needed to study and address challenges to resource adequacy in the MISO footprint. Stakeholders had consistently identified a misalignment between MISO's approach to resource adequacy and the GIP as a top priority for consideration. Also, quite frankly, MISO's internal planning staff was concerned during this period, coming to a head last year, about the relationship between continuing study delays in the queue related to withdrawals and restudies, impeding the interconnection process, and potentially having a result of a looming threat of potential generation shortfalls projected as being 5 years away last year. So that we're looking at 2020 as the capacity shortfall year. MISO was concerned that because interconnection customers are financially responsible for the cost of interconnection studies, the number of studies and restudies that must be performed directly impact a project's costs. And MISO was concerned also that study delays were interfering with customers' ability to timely execute GIAs and potentially to receive timely accreditation under MISO's resource adequacy approach. MISO conducted a survey along with the Organization of MISO States on resource adequacy and explained that the study, which was intended to identify potential generation shortfalls around the 2020 timeframe, found that the majority of the identified 30 gigawatts of planned resource additions for 2020 are, well, at the time, were on hold or they were still in preliminary studies. MISO reasoned that by implementing its process now to try to address the problems with queue processing, it would allow for longer lead time resources to meet the projected need within the identified 2020 timeframe. MISO also explained that while its last queue reform effort provided positive results, frankly it's been the restudies that have been plaguing MISO and causing unforeseen delays. And MISO also believed that it was required by its tariff to identify network upgrade costs that are required solely for the reliable interconnection of each interconnection request. It must also determine if a restudy is required as projects are withdrawn from the queue. The trend was that restudies of lower queued projects were often necessary, and this was exacerbated as there was a frequency of higher queued projects choosing to withdraw later in the interconnection queue process. In addition, although MISO had altered its M2 milestone cash at-risk payments in Queue Reform 3, MISO contended that that condition for entering the DPP gave incentives. It wasn't properly priced and was giving incentives for interconnection customers to linger in the queue until the very last moment, often when the impact of their withdrawal, unfortunately, would be highest on other lower queued projects. And MISO also argued as justification for their changes that if a restudy identifies a new network upgrade requirement for the interconnection customers remaining in the queue, that may cause additional withdrawals. This was a problem observed back around Queue Reform 1, the problem of cascading withdrawals. MISO contended that that process diverts MISO's and MISO's transmission owners' resources from processing new interconnection queue requests and really would redirect that effort to evaluating the impact of the withdrawals on lower queued projects and affected systems. Not without controversy, stakeholders that, in my opinion, succeeded in persuading the Commission of their arguments, pointed out that the somewhat drastic changes that MISO engaged in at this point, they characterized it as such, is different from what other RTOs do when they engage transmission owners and interconnection customers. The protests pointed out that affected systems and transmission owners and neighboring RTOs often and more systematically involve those stakeholders in the generator interconnection review process. The protests identified early engagement and management of the process as going a long way toward avoiding queue delays. And there's a series of additional arguments that, again, I think were persuasive to the Commission. We'll get to these in the next section. That were articulated in the pleadings in the Queue Reform 4 proceeding. So let's go over the high points of MISO's proposal and the guidance that FERC provided in rejecting the proposal without prejudice. So the great change that was indicated was the DPP Structure Changes, and the current process. The majority of currently an interconnection customer first enters the pre-queue phase, during which MISO performs the feasibility study to determine whether the transmission system can accommodate the interconnection request. Following the feasibility study, the project has a choice. It can move directly to the DPP, or it can remain in the first phase of the queue, the SPA phase, as long as they undergo additional study as they linger. If the project is not eligible to proceed to the DPP, the customer enters the SPA and undergoes a system impact study. After receiving its study results, the customer would then have to decide whether to fulfill the M2 cash at risk milestone payment in order to enter the DPP, where, once in the DPP, it would receive its system impact study review that would give it an approximation of the type and cost of upgrades that would have to be funded in order to facilitate its interconnection request. After receiving that information, the next decision point is the customer decides whether to fulfill the M3 milestone and in order to undergo the facility study. Upon the completion of the facility studies review, that's the point at which the interconnection customer has probably the fullest idea of their all-in costs for network upgrades associated with their interconnection, and they would have the opportunity to negotiate an interconnection agreement or proceed to an unexecuted filing. MISO's Queue Reform 4 proposal upended this significantly. The new queue structure, first of all, removed the requirement in the pro forma GIA that a customer with a completed GIA would be susceptible to undergoing a restudy due to a change in a higher queue project. The proposal eliminated the SPA phase, the system planning and analysis phase, entirely, and it altered the existing pre-queue phase by replacing the existing mandatory feasibility study with an optional, non-binding pre-queue feasibility study that was intended to provide preliminary analysis of system impacts from the proposed project so that the interconnection customer could have the benefit of the information prior to submitting an interconnection request. This was now to be called the pre-queue feasibility phase. And the interconnection customer requesting pre-queue feasibility study would pay a $60,000 deposit and a desired schedule to complete studies. MISO also proposed to split the DPP into 3 phases, featuring 2 off-ramps. We'll walk through this. These are the significant innovations that were proposed. The customer would enter DPP Phase 1 by submitting a valid interconnection request, making their study deposits, and the M2 milestone payment. In this phase, MISO would conduct the preliminary system impact study, after which the customer would encounter what was called Interconnection Customer Decision Point 1, a period of 20 days where they could be free to leave the queue and refund their M2 milestone payment, or if they decided to, that's the first off-ramp, or if they decide to continue in the queue process, the customer would then pay the M3 milestone payment to enter DPP Phase 2. Another feature was, as Mike had mentioned earlier, in the DPP phase, previously MISO would view any changes as a material modification to the interconnection request, generally prohibited. The more recent proposal was the customer could choose to reduce the size of its interconnection request before proceeding to DPP Phase 2. Then upon entry into DPP Phase 2, all the projects would undergo another system impact study, taking into account any of those changed facts or assumptions that arose during the DPP Phase 1. After this, customers have reached Interconnection Customer Decision Point 2, which is another 20-day window. They could choose, again, an off-ramp. They could choose to withdraw from the queue at that point, having their M3 milestone payment refunded. However, the M2 milestone payment would be forfeited, and that would be used to reimburse other customers for increased upgrade costs that resulted from that customer's withdrawal. If the customer chose to proceed in the queue, it would then be required to make the M4 milestone payment and enter DPP Phase 3. In DPP Phase 3, again, the customer was subjected to a final system impact study taking into account any changed facts or assumptions that arose during DPP Phase 2. However, in this phase, there is no further interconnection customer decision point. All payments have become cash at risk. During DPP Phase 3, the customer would also undergo an interconnection facility study. Upon completion of the system impact study, the facility study, and the GIP in general, the customer would now be free to seek its generator interconnection agreement to be filed, executed, or unexecuted at the Commission. Once the GIA is executed and the initial payment is satisfied, the customer would be refunded its M2, M3, and M4 milestone payments.
There's also, just for everyone's information, in the MISO filing itself, there's a very helpful chart showing how they propose to divide up the DPP in phase 1, 2, and 3, and where these milestone payments are. It was a significant proposed change to how MISO had previously used this phase. And again, that wasn't adopted, but to the extent those ideas might come back later or to understand what MISO is proposing, the graphic's very helpful.
Along those lines, the Commission actually, although it roundly rejected MISO's proposal, it did have some positive things to say about the ideas. The Commission agreed that MISO's proposal would replace unscheduled ad hoc restudies with a phased study process. The Commission agreed that the proposal would allow interconnection customers to downsize projects at decision point 1 that could be of benefit to interconnection customers. The Commission also agreed that the proposed off-ramps could also be helpful to make sure that first ready, first served projects would proceed, and others that weren't ready or weren't serious would be flushed out, basically flushed out. Negatives. I think that the negative comments from the Commission should be interpreted as guidance on how MISO could improve its next proposal depending upon how 2016 plays out, and we'll cover some of this in our prognostication section as well. But the Commission found that MISO had not adequately demonstrated that its proposed reforms would result in just and reasonable and not unduly discriminatory approach to remedying the identified problem, which was the backlogged queue that may affect resource adequacy. The Commission found that MISO failed to achieve balance. It had not shown that it considered other factors that lead to queue backlogs beside interconnection customers dropping out of the queue. The Commission also did identify that involvement from transmission owners to improve network upgrade cost estimates in DPP Phase 1 or 2 could give customers more useful information, but language in addressing this section and other sections of the order really show that the Commission is signaling that MISO should consider earlier and more structured activity from the TOs and from affected systems earlier in the process. The Commission also found that MISO failed to support the proposed fee for the non-binding informal pre-Q phase feasibility study, and compared that some neighboring RTOs provide similar information that would be available to interconnection customers seeking the models that would be used for studies for a fraction of the cost that MISO wished to charge or for free, indicating that while MISO is not required to show that its reform measures are better than their RTO neighbors, but the Commission pretty strongly suggested that MISO needed to provide sufficient justification for the level of any proposed pre-Q feasibility study fee, and they failed to do so. Similarly, the Commission found that the proposed M2, 3, and 4 milestone payments were not supported as just and reasonable. We'll reach that section now. More specifically, in the current process, MISO requires a cash at risk M2 milestone payment to enter the DPP. It's calculated through a formula that takes into account that MISO's drive-through and drive-out yearly rate and a constant amount per voltage level multiplied by the number of constraints shown in the initial system impact study. Basically, that means that developers can expect a payment that will be capped at $10,000 per megawatt or a floor that's been set at $2,000 per megawatt for their M2 milestone payment. And if the project withdraws into the current system, the M2 milestone payment would be applied to any network upgrade costs experienced by lower queued customers that would basically be stuck with footing the bill for those network upgrades, and the balance would be refunded to the withdrawing customer. Under the proposal, MISO had a similar approach in a capped, floored, and scaled payment for the M3 and M4 milestone payments, but these were new payments from the perspective of generators. Similarly, the payments would be eligible for refund if the customer withdraws at the next decision point. That is, the M2 milestone payment would be refunded if the customer withdraws at decision point 1, and the M3 milestone payment would be refunded if the customer withdraws at decision point 2. As with the M2 milestone payment now, any forfeited cash at risk milestone payments would first be applied to the cost increases for upgrades impacting other customers as a result of the project's withdrawal, and the balance would be returned to the customer. Then all 3 milestone payments would be refundable upon execution of the GIA and the satisfaction of the initial payment. Commission's determination. Rejected. MISO had not sufficiently supported the level of its proposed M2, M3, or M4 milestone payments. MISO had not shown that the proposed milestone payments would not create barriers to entry for smaller developers, and in doing so could inadvertently negatively impact resource adequacy. MISO had not shown that the level of proposed milestone payments was just and reasonable, and a not unduly discriminatory method for accomplishing MISO's intended purpose of preventing projects that weren't ready to be interconnected from entering or lingering in the queue. The Commission also, I think, was persuaded by arguments from some of the protests from the generation community that smaller developers would suffer perhaps bias with the queue favoring utility-owned generation, negatively impacting resource adequacy. If we can read the Commission's discussion in rejecting MISO's proposal, we could read into it some guidance for what the Commission expects of MISO if they're to try again. In light of the claims that MISO's proposal creates barriers to entry that do not exist in neighboring RTOs and ISOs, the Commission found that MISO did not show why the increased cash at risk milestone payments were just and reasonable solution for MISO to address its interconnection queue delays, and suggested that MISO should consider elements of the generator interconnection procedures used in other RTOs to improve MISO's interconnection queue. In particular, they, I think, are referring to PJM and SPP. Also, there was some lack of clarity that the Commission identified in reviewing the comments, protests, and MISO's answers. The MISO stakeholders and MISO differ themselves as to the meaning of the tariff language governing milestone payments. It was not clear how MISO would resolve this. It looks to developers like they would be required to pay the M2, M3, and M4 milestone payments and also the initial payment, nearly tripling their cash at risk, plus suffering the potential administrative delay in getting refunds from MISO. The Commission and the protests pointed to a possible solution, the contrasting practice of SPP, Southwest Power Pool, applying milestone payments to the initial payment. The Commission suggested that MISO should consider applying an interconnection customer's milestone payments to its initial payment following the execution of the GIA or the filing of the GIA unexecuted at the Commission. And the Commission frankly said it was unclear from the record why MISO hasn't done this.
And I think it's also good to point out that MISO's goal here in organizing the payments was partly to set up a system where generators would be incentivized to exit the queue in an orderly manner. So by having multiple milestone payments and making them refundable if a project exited at a certain time, the goal, which I think would be an important one, would be to take the inevitable withdrawals of projects and align them better with the study timeline, so that if projects were going to withdraw from a group, they would do it at a specific point in time where then additional studies could be done if needed. And that would increase the certainty for the projects that remain in the queue.
Okay. The next point that MISO proposed in Queue Reform 4 was a transition plan. The issue is which of the interconnection customers currently in the queue would be captured under the new paradigm. How would you deal with this in a way that was fair and equitable? I'll spare you the details on that section. We're going to try to accelerate a little bit our discussion so we can keep this to an hour with adequate Q&A. In short, the Commission agreed with the protesters that MISO had not shown that its proposed transition plan was just and reasonable as a method of resolving current backlogs. It was unclear how the proposal could be implemented, and it was rejected by the Commission, but without prejudice. And the Commission specifically suggested that MISO should propose a transition plan should it revisit this issue that avoids study backlogs similar to those that were created at the formation of what they refer to as the large August 2012 study group. For those of us who've been practicing in the MISO footprint, this is Group 5. I think that the Commission's motto with Group 5 is never again. And I expect all stakeholders probably agree that hopefully we'll never have a Group 5 cascading restudy ever happen again. The Commission also encouraged MISO to provide stakeholders with a meaningful chance to review and react to the development of a transition plan that follows FERC's guidance. The next major point that MISO proposed was the elimination of restudies. Currently, restudies are part of MISO's existing pro forma GIA, and in short, the MISO was seeking waiver of sections of the pertinent sections of the GIA. The Commission rejected this in its entirety. Basically, it found that, in short, the Commission walked through the waiver analysis that I think it expected MISO should have done in order to ask for a blanket waiver, and the Commission suggested that it would be more appropriate for MISO to simply seek a separate 205 proceeding to re-examine this part of it if it's GIA.
And again, this would have been a pretty significant change to the existing process. The GIA spells out a number of circumstances when restudies are permitted, and MISO's proposal would have eliminated most of those and just made restudy subject to a FERC order.
Speaking of elimination, the next major point of MISO's proposal was eliminating the 25% threshold for milestone payment refunds. In short, the only cost certainty that interconnection customers really have in the interconnection process is the fact that if their expectations on their network upgrade costs are going to increase by more than 25% from their initial indications under the system impact study to their sort of last study, the facility study, that they have a sort of a clean and free off-ramp. And MISO is proposing to eliminate this because under the new scheme, it would still allow for late withdrawing interconnection customers during DPP3. Customers that really weren't quite ready or weren't ready to proceed, they would still be able to exit the queue upon receiving their facility study results as late as DPP3. The Commission rejected this as not justified and agreed with the protesters, frankly, that this really is meant to be a protection for interconnection customers when their expectations as to cost increase. And the measurement that's been found thus far to be just and reasonable in the MISO approach is if your reasonable expectations are exceeded by 25%, you can still get out and recover your money. The guidance that FERC offered was that MISO, should they revisit this, they should consider keeping Section 8.2 of the GIP and provide justification perhaps for a proposed de minimis threshold, and then provide further justification for the removal of this provision, or show the nexus between the removal of the 25% threshold provision and the number of off-ramp opportunities. If this really would have an effect on making sure that first ready, first served projects are being efficiently processed through the queue, then FERC's left the door open that they would entertain the idea, but they pointed to really the lack of any justification or adequate evidence by MISO in its filing. We're getting down to the 10-minute mark, so we will skip through the last couple of points here and get to prognostication and questions and answers. MISO had proposed to continue provisional GIAs. This was an earlier innovation in MISO's interconnection process. and it's continued. The Commission approves its continuance. And the question of the external NRIS milestone payment, FERC punted because there's a separate proceeding that was docketed last week for paper hearing on external NRIS. Finally, there was a table of definitional changes and other changes that the Commission determined that were not justified. Frankly, MISO has had a habit of keeping a list of attachment X changes, sometimes in the nature of cleanup changes, sometimes in the nature of fixes that are generally non-controversial, that are kept by MISO personnel for future fixes at appropriate times when they make a Commission filing. It's my view that most of the table that the Commission rejected, most of these changes were intended to make those sort of cleanup changes, and they were not sufficiently justified. That's why the Commission rejected them. So, prognostication. Let me ask you a question, Mr. Splete.
Yeah.
Procedurally, what will happen next, or what could happen next?
Well, the next procedural method would be rehearing. If MISO wanted to seek it on the Q Reform 4 order, MISO would have 30 days from the date of the order to file a request for rehearing. At this point, I don't think that's very likely, mostly due to the OEA petition in docket RM 15-21 that the Commission has set for technical conference, and that would address interconnection issues across various RTOs, and I think what we'd be more likely to see would be MISO participating in that proceeding along with other RTOs, and then probably going back to the drawing board a little with a version 2 of Q Reform that would potentially be a compliance filing if an order issues from that technical conference, or adopting some of those proposals. But you might also see some of these ideas from the current Q Reform 4 filing come back around again, because MISO would still face those same issues, and some of them are tied more closely to MISO's unique circumstances. So MISO might well pursue those in addition to anything that the Commission would suggest.
Okay. I concur with your assessment, Mike. I'm sure you're not surprised. And I think that probably the technical conference will feature engagement by MISO stakeholders and MISO. I think that the technical conference is likely to identify best practices for RTOs and ISOs, and I suspect that FERC will either order them to be adopted by RTOs and ISOs, a la Order 2003, or request that RTOs and ISOs explain why they shouldn't adopt some of the best practices and defend under the independent entity variation their current procedures.
That was the method used similar to 2008, which led to MISO's Q Reform 1, but
Correct.
also to a number of independent entity proposals from other RTOs.
Correct. I think that sort of it's back to the future again. If that's the case, let's prognosticate further what will come of this. I think it's likely that some best practices will be RTOs will need to engage formally in their process, transmission owners and affected systems earlier and more systematically in the generator interconnection process. We think that'll be a best practice. Early engagement and management of the process. Some RTOs already offer interconnection customers their study models for free or at very low cost. I think that'll probably be a best practices expectation. In addition, transition planning for future Q changes. Again, the Commission was very specific about avoiding the creation of unwieldy study groups, providing more precise information about the projects that will be grouped together for study, explaining in more detail the timing of the studies, and then finally just avoiding discrepancies between tariff language and the description of the tariff language in MISO's transmittal filing, which really was one of, I think, the defects in the filing that MISO made and caused this result, or this reaction from the Commission. So I don't think we're going out on a limb on those 5 points of prognostication, but hopefully it's helpful to some of our listeners. We're getting to the last 5 minutes or so of our presentation, So at this point, we should probably reveal the CLE code word for those wishing to get CLE in New York and California. Mike, that word is?
The word is Heartland.
Okay. H-E-R-T-L-A-N-D. Okay. If you have any questions, please submit them under the chat function that you have on the ReadyTalk interface. And as a first question, Mike and I had talked about this earlier, so our canned question is, what advice do we have for generation developers?
Sure, and I think from all of the work we've done on MISO generator interconnection agreements, I think really the important thing for developers and really all participants is just to be prepared and to engage with MISO in the process. MISO sets up a structured call schedule for a reason, but you can reach out to MISO staff at any time to be better prepared and engage with the MISO staff and also particularly transmission owner staff in order to make these calls as productive as possible, because oftentimes you would have, everyone needs a deadline and you would have a call set up, but oftentimes people would be scrambling to pull things together before the call or that were needed on one call or the other. And I think it really helps the process for there to be no real surprises and to have a two-way street of information sharing in order to have the most efficient use of the time, even down to just some of the logistical items. People who've been in the process before know that MISO would ask for things like one-line diagrams, and that these need to be updated and checked and be legible, particularly to have them memorialized in the agreement. And sometimes some of those smaller technical issues would take up more time really than they needed to. So even though there's something of a chicken and the egg issue sometimes in the discussions, I think, where it's frustrating from the developer side that it seems as though they're not getting the results that they want in time. It similarly can be frustrating for transmission owners and for MISO when they don't have all the information from the developers as well. So I think really for all sides, just being prepared for the process, which does run on a pretty tight timeline, even though it seems like a lot of time, is really the best thing you can do to move projects forward faster until we have improvements to the existing process.
Okay. So in summary, that was maintain your call schedule, make the calls as productive as possible, and don't be limited to only the call schedule, but be aware that you can talk with MISO staff and with TO staff at any time to try to be as efficient as possible on your working time together. Okay. We're pausing to read questions coming in, which are difficult to read. Okay. A good question pertinent to MISO's reasons for making Q Reform 4. Do you think if resource adequacy concerns grow in the near term, that FERC may be more willing to let MISO make similar Q changes? That is, be less strict in their review of changes. I guess two thoughts on that. One is I do not think that MISO will again make a Q Reform filing that does not have adequate substantiation based upon their treatment or the result in their more recent effort in the Commission order we saw last week. And MISO is likely, should they attempt it again, they will provide the information and follow the guidance that the Commission has given. Secondly, I think that the Commission will be, and stakeholders will be sensitive to resource adequacy needs as we approach the potential shortfall in 2020. I think that the Commission will probably approach a balancing approach, the need to make sure that adequate capacity is being built out versus making sure that the process is not unduly unjust or unreasonable for interconnection customers.
And I think the Commission would be very sensitive to MISO regional specific concerns that would be, if they're well articulated in the filing, I know for cost allocation purposes, a number of years ago, there were specific concerns in particular areas of the MISO footprint where a lot of transmission was being built and the cost of network upgrades was really impacting particular transmission owners, and that the Commission took that into account for cost allocation purposes.
Okay. We're really down to our final minute. We've been requested to repeat the code word for New York and California CLE. The code word is Heartland, Heartland. Looks like there might be a couple other questions that have popped up. We would invite you at this time. Don't hesitate to contact me or Mike directly if you have any further questions. Thank you so much for joining us today. We hope that this has been at least educational, if not entertaining. Thank you very much for your time.
Ladies and gentlemen, that does conclude the webinar for today. We thank you for your participation and ask that you please disconnect your line.